Hey everybody, Brian Boggs. Hi my friend, good to see you. Tammy 13, my love. I'm so happy you're here. Yay. Did you guys see I had to change the name of the stream? I hit 1,500. Yay. 1,500 amazing, wonderful friends. You guys are the greatest. I swear. When I saw that, I was just astonished. I am so grateful every day. You guys, you make me laugh and smile, and you give me something to do with every waking moment. Oh, so I've got some fun stuff for the 1,500 subscriber special. Couple of lawyers behaving really badly. They're intermixed with another docket, and the first clip is kind of wholesome. I love it. Hey, you. That is how your message comes up to me. I love it, though. Hi there. So happy you made it. I hope you're feeling well. I don't know if you heard the big announcement, but I'm at 1,500 subscribers. So happy. My day is officially made. So, I think we're just going to get right into it. Oh, I'm sorry. I had to shower. Trust me, you did not want me on pre-shower. Oh, thank you so much, sweetie. That means a lot to me. All right, here we go.
$00915, the city of Berkeley versus Marlon Tab.
Good afternoon, Sharissa Johnson. On behalf of and with Mr. Tab, we're both appearing via Zoom without any objection. Mr. Tab, state your name for the court.
Hello, my name is Marlon Tab.
Magistrate Chisholm, it looks like we're here for an arraignment on a bench warrant. We'd ask the court set aside any bench warrant. He did walk in today. It looks like the last date he was here was for a pretrial. So I did talk to him and advise him of his rights again with regard to having an attorney appointed at public expense. He is asking the court to make sure one's available for him at the next pretrial date. And I'd like to address bond at the appropriate time.
Recall the bench warrant. He has been arraigned once and never got to the pretrial, so we'll reset the pretrial. Note that he's requested assigned counsel.
Thank you.
Then Esteban, please.
Thank you. I'm hoping that the court will consider a personal bond. I know this is an older file. My client was very candid and he said, you know what, I may not have been responsible and overlooked my court date. He wasn't quite sure what happened such that he missed the court date back in 2017 for the pretrial. However, he is trying to get his license back now. He's going to the various courts in order to get those matters resolved. He does have a good address in the city of Royal Oak. He also
Y'all, I just got a cat attack and he spilled my coffee. So pardon me while I clean up my coffee that this little man just spilled all over the desk. Oh, I love him.
gave me a phone number and an email address so that the court could make sure they were able to reach out to him. So I'm hoping the court will consider a personal bond and any monies that he does have available today that he can use towards paying his clearance fees first. so that he can try to resolve some issues before he comes back for the pretrial.
Did you give a new address on a yellow sheet of paper? Let's see.
Mr. Tab,
Yes.
did you fill out a yellow sheet of paper with your updated information for the court clerk?
It was a lady at the desk. She might have
Yes.
picked it up. Asked for my she asked for my ID, but I don't know exactly what she was filling out.
Okay. I can put it in the chat if you'd like, Magistrate Chisholm.
I would. If you
Okay.
could, the address, the email, and the phone number, I'd appreciate it.
Sure.
This guy lives in the loudest house ever, I swear, where he has a big old party that does not know
Mr.
that
Tab,
he's
you
in
can
court.
check the chat. There's
Yes,
a
I
little,
see it.
is it correct? Did I put
Yes,
the right information? Okay, good.
Everything's correct.
Perfect.
Okay, that does leave us with the bond issue.
I'm sorry.
Where's he working?
I apologize. Did the court not hear my argument? I thought I elocuted really well.
It may have been muted.
Oh, I hope not. Mr. Tab, where are you currently employed? That's not one thing that we did discuss.
She allocated like I stream silently.
Oh, I actually employ myself. I make custom shoes and clothes for people. I got my own business.
Okay.
Been doing it for like 5 years now.
Custom shoes.
Yeah. So you would like, say for instance, if your grandson graduated high school, you would bring me the shoes that he would like, and I would like put all the what? Can I show you?
Sure.
I also asked about the monies that he has going towards clearance fees so that he could try
Yes.
to, okay.
I did hear that.
Okay, so these shoes right here I made for all the dancers for the Detroit Pistons.
Oh, neat.
Yeah.
Very nice.
I made these for one of the players that play for the Detroit Lions. And then this is like my social media page right here with like all my work on it. So if you can see that, and then you just like
Well, that's amazing.
He's incredibly talented
appreciate you.
and cute.
Yep, so I just work on jobs like this for people every day.
Very talented,
Well, the
Mr.
high
Tab.
school, you probably weren't even thinking about anything like that.
No, I actually synced it on YouTube about 6 years ago. I was unemployed, and I just started telling myself I could do that and taught myself how to do it and started doing it.
Good for you. Yeah. Now, this court has a program called Operation Drive, which has gotten several thousand people back on the road legally. So you don't want to miss the pretrial.
I'm not gonna miss it.
No, and I don't need to tell you how hard it is to do business without a driver's license.
That's exactly why I'm trying to get my license together.
So I'm going to provide that you can pay the reinstatement fee on this matter prior to the final disposition. You've been suspended on this because it's 6 years old. So the reinstatement fee, it's not like the old driver responsibility fees that you might remember. The responsibility fee is like, if I tell you $45, I'll be ballpark. That's basically just a bookkeeping fee. It's not the old punishment, $500 or $1,000.
Okay.
So the bond that you paid back 5 years ago, 6 years ago, was forfeited back in April of 17. So that's gone. Set the new bond at $2,500 personal. You don't need to pay money to leave the courthouse. It's a personal bond, just don't miss court. I'm also going to provide that you may pay the license reinstatement fee prior to the final disposition.
Okay.
Now, you might have 3 of them going here. I don't know. Because you got 3 tickets at the same time. So maybe there's 3. We're checking the computer.
Okay.
Now, that would eliminate this court as being the reason that you can't get your license back. It doesn't have anything to do with courts outside of this court.
I understand.
But just because we've eliminated the suspension, don't fail to come back, because the Operation Drive program can be very helpful to you.
Okay.
3. Okay, you got 3. Ms. Johnson, are the license reinstatement fees still $45?
It's my understanding they are.
Yeah. So that'd be $135.
Okay.
But so I've set a personal bond. You may pay the license reinstatement fee prior to the final disposition, and you don't want to miss the pretrial.
I appreciate that.
Good luck to you.
Thank you. Do I pay that outside here?
Say again?
Do I pay that $135 that you told me? Do I pay that here outside the court?
Oh yeah, you could.
Okay, thank you.
And the other thing is, they could give you the date for the pretrial too, if you're willing to wait.
I will.
Okay. And then if they hand it to you, there's less chance that we'll get lost in the mail.
It's not gonna get lost this time. I assure you that.
Thank you.
Thank you.
So if you go to the counter and let them know that I promised you that you could get the notice of hearing today.
Okay, and will they already have the records of me having to pay the clearance that you just said?
At the time you get there, yes.
Okay, thank you, sir.
Thank you. Good luck to
You
you.
have a good day. Thank you.
Amir Walker is in Berkeley custody. He's the young gentleman that was charged with the 2 counts of larceny. And
Is that in reference to the porch? I mean, the car?
yes,
Okay.
they were stopped in a vehicle, but basically the allegation is porch pirates.
The allegations were what?
A porch pirate.
Okay, porch pirate. Got it.
That's Amir Walker.
Should be good now.
Okay, we've got Mr. Walker.
They're here, registry.
Okay, good. Mr. Walker, we're going to put you in what's called a breakout room. It's a virtual conference room, so you can speak with Attorney Johnson in privacy. The court will not be a party to your conversation with the lawyer, but you'll have a time to meet with the lawyer before the arraignment, and it'll be breakout room 1. You should see it on your screen just about now. Ms. Johnson is already there waiting for you. Good afternoon, officer.
Good afternoon. How are you?
Good. We've got Ms. Jenslack coming in, I hope. No sound yet. Got video, but no sound. Now we've got sound. This is 23 RO0 7132. Ms. Jenslack, the ticket goes back to the 9th of November. It was issued about 2:15 in the afternoon. In the area of 13 Mile Road in Benjamin, you were cited for speeding. The ticket was written 40 and a 35. The options are 3. You can admit responsibility or deny responsibility. You can admit responsibility with an explanation. How do you
Yes.
wish to proceed?
Well, I would like to admit a responsibility with an explanation.
Okay, and what is that, please?
Well, I have a good driving record, and I'm hoping that the court will consider taking that into consideration. I would pay the fine, but if the court would waive the points, I would truly appreciate it.
Can't waive points, but maybe Officer Carter has a solution for us here. I don't know.
Okay,
Yes, Your Honor, I'd like to motion to impeding.
Just Jensek, what the officer's motion does is it takes it out of the realm of points.
oh, wonderful, thank you very much.
No problem.
Thank you, Officer Carter.
No problem.
And to impeding. Impeding is not a moving violation. That's why it doesn't. And the fine on impeding is $175.
175, sir, not
Yes.
130?
No,
Not one-
the speeding ticket would have been 130. Impeding is 175.
Okay,
You can
would
pay
the court, oh, I'm sorry.
Go ahead.
I was just gonna say, I'm a retired person and I have a good driving record. Can we waive that?
No.
I'm sorry, sir?
No, the fine
Okay.
will be paid.
Okay,
You can pay it online. You can mail in a check or money order, or you could drop by the courthouse and pay it at the counter. Do you have
Okay.
any issues in making payment?
I'm sorry, sir, what did you say the last thing?
Do you have timing issues as to making payment?
No, I do not have timing issues, sir.
So you can pay it online, mail in a check or money order, or drop by. But thanks to the officer's motion, there's no points.
Yes, and thank you so much for that.
Thank you. Have a good day.
Thank you, bye-bye now, thank you.
Samuel, can you hear me?
Yes, I can hear you. Can you hear me?
Yes. This is ticket 23 R07122. Goes back to the 9th of November. Was issued about 8:40 in the morning
Yes.
in the area of Royal Oak near Woodward Avenue in Berkshire, and you were cited failed to stop in the assured clear distance ahead. There's
Correct.
three options. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Well, this accident was my fault. But this is my first offense, so I'm just here to see if I could remove the points from my record so that it doesn't affect my insurance.
Was anybody hurt in the crash?
No.
Officer Carter, is there anything you'd want to add to this?
Yes, Your Honor. She does have a good driving record and there was no injuries, so I would like to amend it to impeding.
Samuel, impeding does not carry points.
Oh, I did not know that. That's why I wanted to schedule the Zoom today.
Right.
She is so innocent and so sweet. I absolutely adore her.
So,
I'm so sorry.
no. That you were cited for failing to stop in the assured clear distance. The officer's motion is to change it from that to the infraction impeding. And impeding does not carry points. What you
Okay.
were cited for did carry points. So the fine on impeding with a crash is $220.
Okay.
You can pay it online. You can mail in a check or money order, or you could drop by the courthouse and pay it at the counter. Do you have timing issues with making the payment?
What was that? I'm so sorry.
Do you have timing issues with making the payment?
I could make it on I could pay right now online.
Yeah, that'll work.
Okay.
Then thanks
What's
to
the
the officer's
website?
motion, there's no points.
Look at that. She doesn't even ask if it can be waived after they did her a solid.
Okay. And what is the website? Where do I go to pay?
The 44th District Court website. Just make sure that you hit the 44th District Court in Michigan.
Okay.
I just put in 44th District Court once and got to Texas. So you don't want to play that. So just make sure you're in Michigan. You get to the court's websites and there's a series of prompts to make payment as easy as possible.
Okay. And how long do I have, like, if just in case I have technical difficulties and I want to pay in person, how long do I have to pay?
Days would be fine.
Okay. All right.
It's not a problem.
Okay.
Good luck.
Thank you. Happy holidays.
You too.
Me too.
Thanks.
Mr. Walker is with Attorney Johnson in a breakout room. as we speak. And as soon as I said that, she left the breakout room and she's here. So we'll close the breakout rooms and that'll bring back.
Don't worry, it gets weird a little bit later. But these are cute. And I said I was going to do something wholesome.
This is file 23-02222. People of the state of Michigan versus Amir Walker.
Good afternoon, Teresa Johnson. On behalf of Mr. Walker, do you hear the feedback?
Yes.
Okay, I don't know what's going on. So we're here. So we're here today for an arraignment on charges of burglary or porch pirating in common terms. I did explain to Mr. Walker his rights with regard to these charges. We do acknowledge receipt of the charges, waive formal reading, and stand my client mute. I would also ask the court to enter a not guilty plea on his behalf.
Thank you. The next step in the process, Mr. Walker, will be a pretrial conference. You'll be notified of that conference date and time by mail. It will, in all probability, be another Zoom hearing, not the same numbers as today. Do you still live on Winthrop?
Yes, sir.
And your phone number ends 3133?
Yes, sir.
And Ms. Johnson, is Mr. Walker requesting appointed counsel?
He is Magistrate Chisholm. And I also have an email address I'll put in the chat.
Thank you. Then before you speak to Bond, let's hear from Detective Hatfield, please.
Thank you.
Good afternoon, Your Honor. Lieutenant Hatfield, Berkeley Police Department. Your Honor, the incident was submitted to the prosecutor. Our total value was around $1,300 of items found in the vehicle, but we were able to identify only 2 victims at this point. Both of their packages around $200. So I think there's 2 counts. In regards to Mr. Walker, there's no prior criminal history. He's been very cooperative with me last night. And again, this morning, as well as another agency that is came to speak with him today. He's been very cooperative with them. And I think that should go a little bit towards what's going on. Obviously, we have a concern of what the crime is, especially going into the holiday season. But on that stance, we'll let the court decide bond.
It works. It's
In the vintage Isle of St. Vincent.
So he is cooperative. Have you had contact with his parents?
Sorry for the phone call here. Yes, Your Honor, I have spoke with both the mother and the father, who are aware of what's going on. There is another sibling, is a minor, that we're not discussing at this time, but we're all aware of what's going on. They've been at least cooperative to that point. Sounds like he is living with them, does have a job in the area.
Ms. Johnson?
Yes, thank you. That is accurate. He is living with his parents. They don't approve of his behaviors or the alleged behaviors of my client. He is 20 years old. He works at the Ford industrial plant on the assembly line, and this would have been his second day at work, but he's missing it currently. I am hoping the court will consider a personal bond. He, as Lieutenant said, he does not have any prior criminal history. I know that he's also been questioned about something in Dearborn, but these are not violent crimes, although it could have been a lot worse if in fact somebody had opened the door and saw what was going on and confronted him. But again, he's 20 years old, never been in trouble before. So I just asked the court to take that into consideration, but I think a personal bond would be appropriate.
And if he hadn't have been porch pirating, he would be at work today, making a legitimate paycheck instead of thieving.
Mr. Walker, bond is not a punishment before the trial. Bond is designed to make sure you appear in court as directed, and it's designed to ensure the safety of the public pending the trial. I can't tell you that I believe that a couple $300 or $500 coming out of your pocket would change either of those factors substantially. So I'm going to set up the bond at $5,000 personal. You don't need to pay money to get out of jail. But I'll tell you, without equivocation, that failing to appear in court would be a terrible mistake. There's certain benefits to your age, based on your age, that without a record, you might be in a position to control the damage in this matter very substantially. You don't want to miss court. You really don't want to miss court. So the statutory terms and conditions of the bond, you can't leave the state, you can't commit another crime while you're on the bond if that's a violation. You can't miss court. You just show up as directed. We've got the address on Winthrop. That's where the notice will be sent. I believe the pretrial will also be a Zoom hearing. But when you get the notice, it will be very clear if it's in person or Zoom. I think that'll do it. Thank you.
Thanks, sir.
Thank you.
Mr. Everett's probation officer came to speak with me earlier this afternoon. And he told me that even though the notice that was sent by the court for the hearing that Mr. Everett missed had the date to be the 6th, that he had told Mr. Everett that the date was going to be the 13th. And
Okay, wow.
so the probation officer made it very clear that he believes that this could have been just a matter of the defendant not looking at the mail. It was exacerbated by the fact that he could very well have relied on what the probation officer told him.
Mm-hmm.
And so for that reason, I think the bond that was set, the bench warrant was issued, would be susceptible to serious modification. So we'll put you in a breakout room. Mr. Everett, you're going to have a chance to speak with the attorney in privacy before the arraignment on this bench warrant, but you heard what I told her.
Yes, sir.
Okay. So it'll be breakout room 1, and you should see it on the screen just about now. Ms. Johnson is there waiting for you. Ms. Hicks, I'm sorry, I didn't know that I was muted.
Oh, no, that's okay.
This court administrator came down and told me that they have no paperwork yet. I suggested we extend the delay for 15 minutes. We usually set off the line at 3 o'clock. And we've extended it so by 15 because people have to be able to leave the courthouse. But in the event that it's going to happen today, it's going to happen within the next 10 or 15 minutes. If it doesn't happen, then it will either happen tomorrow or
Okay.
no more.
He's giving wrong information. There's no charges right now.
Nothing has been received from the prosecutor's office to the court.
Right. There's no charges, and that's why we're here today.
I have George and I'm sorry, Mike.
Steinberg.
I feel sorry for this woman. She has 2 angry old men lawyers just storm into the office and demand to speak to the manager right now, basically.
Magistrate, good afternoon. It's Attorney Mike Steinberg. I'm over here. We're trying to get in touch with Judge K right now. Because this gentleman's been in custody for almost 72 hours with nothing.
I believe he was arrested on Saturday night. I think we're pushing 48 hours.
Well, 48 hours, and we've gotten word from the prosecutor today that they are not issuing any charges today. They may not issue charges.
You haven't gotten that word, Mr. Steinberg. They may have told you more than they told us.
They did. And
Yeah,
actually, talk to the attorney that actually spoke to this
today. Good morning, Judge.
Or
Afternoon, I'm sorry. Yeah, that's exact. First, they told me they're going to bring charges. Half an hour later, they said, we've decided we're not going to bring charges, and we may not make a decision tomorrow or the next day, too. And I said, well, wait a minute, we can't do that. And she said, we've already told the Royal Oak Police Department that they should do the right thing. And I said, okay, let me call the OIC, which I did. And he said, well, my boss has now called, the prosecutor's office, and let me see, because it may be him calling right now. But anyway, the prosecutor told me they are not charging at this moment. They're not charging for the next couple of days. So that's where we are.
Right. So that's a problem, Don.
Yeah, because it'll be, it is 48 now, or close to 48, and it will be 72. And frankly, Judge, the guy, is really a fragile kind of person. And this is real, and he's 47 years old, no record whatsoever, employed. This is his wife. He owns property in Detroit. He's not going anywhere. And
Well, I was going to ask if it was one of his morning Metamucil buddies, but he's only 47. It's like half this dude's age.
And we just need to get him out for his health. And also, the prosecutor told me in so many words half an hour ago that they may not make a charge for several days. I think they've got videos and all of this, and that's fine. They take their time.
They may not charge at all.
Yeah,
that's a problem. So, and here's the thing.
The other alternative is the city could bring the charges.
Well, I'd love it if the city would make the charge.
They could.
And I guess what I'm saying to Magistrate Chisholm is we got a man who's actually got some medical conditions sitting in a jail cell right now. So if you don't feel comfortable in issuing a writ, then we'll go, we're standing outside Judge Kolakowski's courtroom with the intent of just saying we need a writ at this point. He's got medical, his wife is sitting here. She's prepared to testify to his medical conditions. And it's I'm the one to help create the MIDC, and this is not designed to keep somebody sitting in jail for 48 hours.
I understand that. And you understand that I can't arrange somebody on a charge that hasn't been brought.
Right. I know. My purpose of talking to you was, are you comfortable in issuing a writ? If you can't, the statute allows you to issue a writ. If you can't, the backup plan is to go in front of Judge Kay and see if he'll issue a writ. And if not, we'll drive out to Oakland Circuit and see if the chief judge will issue a writ. It's just, I got a unwell man sitting in a cell right now.
And the prosecutor telling us maybe several days before they decide what they want to do. So,
well, as I understand it, the maximum they can wait is the 42 hours, or the 72 hours.
Well,
in terms of bringing the concept of a writ, I'd suggest that you bring it to Judge Kolakowski.
There you go. Thanks. I appreciate that, Don. I appreciate it.
All right, thank you, Judge. Okay.
Thank you.
That cannot be ethical. I just can't even imagine that being any form of common practice to ask a judge for special favors like that. The guy, there's nothing to arraign him on. Charges haven't been brought yet. He's going to sit in jail until he sees the judge on charges like everyone else.
Thank you.
Okay, now I think we have Mr. Everett.
Yes.
This is file 22-01352, People versus Wilson Everett III.
Good afternoon, Sharissa Johnson on behalf of Mr. Everett. We're here via Zoom without any objection. Mr. Everett, state your name, please.
Wilson Everett III.
Magistrate Chisholm, we are here today for a bench warrant arraignment. We are asking the court set aside the bench warrant. Mr. Everett, once he realized there was an outstanding warrant, did turn himself in. I think it's just an issue with regard, like the court said prior to the case being called, a mistake as to dates and times that my client was supposed to appear to meet with probation. He's kept in touch with probation, has continued to keep in touch, and hasn't missed anything since that last time. And even when he found out he had missed a date, he still reached out to his probation agent and maintained contact with his agent. So he is here today to get this set aside. And I think we just need to get him back on track with meeting with probation and coming back to court for whatever dates are next.
The actual violation that was alleged was testing positive. So it was the hearing that he missed, so we'll reset the hearing.
Okay, got it. Thank you.
Is he continuing to test?
He is.
Yes.
And then the bond that was in place before that, I'm going to
Reinstate.
reinstate the bond.
Thank you.
Mr. Everett, I want you to know that your probation officer came down and spoke with me. And he spoke on your behalf. So you've done the right thing by physically showing up today. It's the best thing you could have done. And,
Magistrate Chisholm, I'm sorry.
Go ahead.
The only other thing that Mr. Everett wanted me to make sure I referenced today was that he is supposed to test today. And because he's here at the court, he is not going to be able to make it to the testing location because of transportation and the fact that they're using public means to maneuver around. So I just wanted the court to be aware if there could just be a note in the file that if he misses today, it's because he's here. And I don't know if he can even test today with his probation agent while he's here or not, but I just wanted the court to be aware.
You're putting that in the file.
Thank you.
Wouldn't be a bad idea if you dropped in and saw your probation officer. You
sorry.
are in the building now, right?
Yes, I am. I'm in like a break room outside.
Drop in and see him and let him know about the testing thing. I've noted in the file that you can't test today because you were physically in the courthouse.
Yes, sir. I did speak with him this morning when I first came in, and he told me to go around to the clerk's area, which I did.
So go on back to him and you can tell him that I've reinstated your bond.
Okay, thank you, sir.
So good luck to you.
Thank you, sir.
And showing up was the best thing you could have done.
Yes, sir. I'll never leave. I'll never not come to court, sir. Never. So I took off work. So hey, I'll never do that, sir. Respect to the city.
Well, good luck to you, and I hope you have a happy holidays.
Yes, sir. Thank you.
Thank you, Magistrate Chisholm. Take care, Mr. Everett.
Thank you. Thank you as well, Ms. Johnson.
You're welcome.
They're on their way. Ms. Johnson, they're on their way with a device into the lockup in Royal Oak for Jessica Lynn Woods. Her charge is it's like a UTA.
The 2-year?
Say again?
The 2-year?
The 5-year.
Oh, the 5-year. Okay.
And there is, I want to verify there is but one count. Yep. And there was a matter dismissed in the 16th District Court in 22. Another matter dismissed in the 36th and 23. There was a guilty plea in June of 23 in the 17th District Court. I think her fine was $125 and 8 days in jail. So that's, I think, all that's pending.
Okay.
And okay, sorry, PD jail.
Don't mind me for going in and out of camera. I'm still cleaning up Billy spilling my coffee all over my computer desk and computer and phone and everything else.
We have Ms. Woods.
I had to leave this in. Michigan.
What? Are you? I'm from the court. We do your arraignment, start working on getting you out of here.
She might be hiding since, the cat
Bring
dumped
it
her
in.
off there and she was under the
Or we
desk.
go to the front. We just pull like that and it'll flip the way you want it.
I'll call her after this clip.
It should go. Let me make sure. Hold on. There we go. I think we're good now.
Peekaboo.
Ms. Woods, can you see and hear me? Okay, we're going to put you in contact in a breakout room, which is a virtual conference room. And you'll be able to speak privately with Attorney Johnson in that breakout room before your arraignment on this felony. So it'll be in breakout room 1. Ms. Johnson is already there waiting for you. So if you join the breakout room, you'll be able to speak with Attorney Johnson privately.
No charges yet. So they're gonna hold him more than likely until tomorrow. So nothing's gonna happen today.
They're going upstairs to see if they can get a writ from Judge Cole.
What's writ? For what?
Because the prosecutor's office.
He's like, quick, cut the mic. Someone came in. Nothing's going to happen. They were talking about those 2 lawyers that were in there behaving badly. Oh, but. That's not all I have for you guys tonight. No. But first, I have to get Ava because she has been requested. And yes, that was Michigan, for sure. He even said it at one point about making sure to pay it, 36th district. Ava, your audience awaits, my dear. Come here, baby. Come on. Aw. Yes, you're my favorite tonight because you didn't dump my coffee all over my desk and stuff. Such a pretty girl. Such a pretty girl. Yes. Mama hit 1,500 subscribers. What do you think about that? What do you think about that, huh? She's tearing the place up. Her tail just knocked over my garbage can. Oh, you guys. That's probably my daughter telling me that I'm being too loud. So I should probably close my door. Oh, she is. She's my love. That's our intern. Yes, CEO intern. Ava can't get any treats for about 2 weeks. We ran out. And so it's 2 weeks until I get paid. And so she's just going to be out for a little while. But, oh, Brian Buggs, that is not allowed. What was I going to say? Oh my goodness. I had something to say and now I can't even remember it. See, that's why I interrupt, that's why I interrupt the shows, because if I don't say it, I'll forget it. But then I get nasty comments in my in the comments on the videos, and they're, people are like, you interrupt the flow. Stop talking during the cases. So, yeah, but that's not working out for me. Because then I can't remember anything. There, I had to turn my phone on silent. Oh. Yes. She gets lots of those. All the time, spoiled. All right, I am going to put on now a little bit of clarity for this one. I don't know what type of case it is exactly. But it's a good one. And I obviously don't have all of it, but oh wow, what I've got is a ride. Oh, good. I'm going back to it because I can't stand this waiting until the video is over crap. Hey, sweetie. Good to see you. I'm happy you made it. I'm at 1,500 subscribers. Oh, just so you guys know, the website that is mentioned on the video is not the whole website. I clipped out part of it so people could not go to the website that's mentioned. So before you think of, mobbing or doxing or anything, and if anybody does figure out what site it is or whatever, please don't, go posting where it is or what it is or who it is and stuff like that. I'm just saying that for legal reasons.
Counts here. She could have requested.
Your Honor, my question was what formulates her belief that he can afford it? This is how she has formulated that belief.
Well, her belief is not what's relevant.
I'm going to sustain the objection.
You participated with Stan in filing your taxes for 2022, correct?
Yes.
So you can see, you at least saw what Stan, you saw Stan's financial position for 2022, correct?
Yes.
And based on that, do you think that he can afford to pay some of your attorney fees?
Same
Yes.
objection, Your Honor. She could have produced the tax returns. We could have seen them. This is hearsay, and it violates the best evidence rule as well.
Your Honor, I'm asking, they filed joint taxes. They saw one another's taxes. We're not disputing what those numbers are.
And we could have put those records in front of you, but they're not doing that. They're just testifying about what appears in an out-of-court document.
Sustaining the objection.
With regard to Stan's testimony on the I think it's Bluestone, we had asked him through his attorney for more information about that, correct?
Yes.
And we didn't get it till I asked him those questions here today, correct?
Yes.
I'm going to object to continued leading questions. I've tried to let it go a lot in the interest of time, but now it's to the point where counsel is testifying.
Sustain, just rephrase. Go ahead.
Thank you. Is that an issue that wasn't addressed by the PC?
It was not addressed by the PC.
Okay. Do you feel that issue's all the way resolved?
No, I do not. In October,
well, let's be brief on that. Has that issue been resolved?
No, it was, I believe Mackenzie told me that her father and her father's girlfriend
I'm
dressed
gonna
her
object
up,
to, I'm
put
objecting to
products
hearsay
on
again.
her.
I'm objection
Kristen,
hearsay. We're talking about what a child is saying now out of court.
Kristen, you can't say what Mackenzie said.
Okay.
Okay.
Go ahead.
I'll just ask you, do you think that putting a child on social media as an influencer is in her best interest?
No.
Did Stan talk to you about that?
No.
Are you asking, well, don't strike that. Nothing further, Your Honor.
Cross.
Close. Whenever you objected to the picture of Mackenzie being online, it was immediately removed, wasn't it?
It was removed because I emailed the company and asked them if they had consent to put Mackenzie's photos on their Instagram account and link a product that she was wearing to a shop.com website that Miranda, Stan's girlfriend, had posted on her shop.com page.
I'm going to object to lack of foundation beyond
And
the scope of
as a
my
result
answer
of
of my
that,
question.
Okay, hold on. Hold on. You did ask the question. I think the answer would actually be a yes or a no at this point. So why don't we answer yes or no? Or I don't know, or I can't answer. Give me something.
I'm not sure what Mr. Dehem is referencing about immediately taking down the photos. I was the person who contacted the company, advised that they did not have my consent to post her photos on Instagram.
Hold on a second. Mr. Dehem, the answer is no. The answer is no. It's okay, Kristen. Ask another question, Mr. Dehem.
All right. And Ms. Klaus, to your knowledge, just to be sure, that picture is no longer online, correct?
I have no idea. I do not know what is online and what's not online. I don't look at that page every day. I know at the time I was told it was taken down.
Okay. So you were told it was taken down, right?
Yes.
And you have not seen that picture back up, have you?
Objection. Asked and answered.
Sustained.
Have you seen any other pictures of Mackenzie put up on a website like that since you objected to it?
I have not seen photos of Mackenzie on a website like Bluestone, but I also have not looked for them.
Okay. And Stan has not told you that he's going to somehow post these pictures or anything like that, has he?
No, he has not ever asked if I was okay with him using images of our daughter to make money for his girlfriend or in any other capacity to get free products or do anything else. He has never asked my thoughts on that at all at any point.
Take that one as a no as well. With regard to the money, the attorney fees that you owe, you're an attorney, right?
Yes.
What firm?
God.
Taft, Stetness, and Holster.
Are you an associate, a partner? What are you?
I'm a partner.
What's your annual salary, including bonuses?
My compensation has decreased dramatically over the last 2 years. And I don't know yet. Stan has my tax returns from last year, so he knows.
I appreciate that, but my question was, what is your annual salary? And you said you don't know what your current salary is?
I do not have a salary. I'm only paid on revenue in the door. I do not get a base salary.
Okay. Let's say before this tax year, let's say for tax year 2021, do you know how much you made gross that year?
$230,000.
Isn't it true that it was actually between $400,000 and $500,000?
That's not, no, that's not true. That's not accurate.
Okay, you're aware.
Yeah, and I was waiting to interject and answer a few of these until after you guys heard that she was a lawyer. So you cannot convince me that she doesn't know what hearsay is, or that when there's an objection pending, you stop talking, or that you don't talk over another attorney or the judge. But this woman just does it all. But oh, wait, it gets worse. And as far as who the judge is, I am not sure. I can't read her name. She might say it later in the clip. But this is, I believe, Indiana. This is one of my exclusive streams.
Aware that we can get those records, and if what you're saying is not true, we'll present those, right?
So my partnership years are not calendar year. So are you asking me about my compensation, my calendar year compensation?
Ma'am, I'm just trying to find out how much you make, and however, maybe you can explain it. How much do you make a month?
I make zero a month unless I get paid by, I make nothing. I make nothing. I only get paid when clients pay me.
And you said you're a
I
partner?
used to have, yeah, I used to have a salary, but I don't anymore. I only get
Okay.
paid on revenue in the door.
How much did you get paid in November of 2023? This is the
Why
last
is
full
that
month.
relevant? Why is this relevant? November of 2023. I think I was paid $20,000.
$20,000. Is that approximately pretty standard for how much you make a month?
No,
How much do you normally make a month?
I don't have a normal compensation that I make. As I explained to you, Mr. Dehem, previously, I make zero. I do not have a salary. I make nothing on a regular basis. I only get paid when I get revenue through the door.
Child's a teenager.
I understand that you're saying you don't have a salary.
I don't know who it
and I
was.
understand.
For example, in October, I made nothing, zero, because I didn't have any revenue in the door.
100%.
So have there been months where you've made more than $20,000?
Yes.
Okay, what is the highest grossing month that you can remember?
Objection,
Number, I mean.
Your Honor, can he define what year we're talking about? Are we?
Sure, can narrow it a little bit, Mr. Dehem.
Let's say, I mean, we're going back, you're asking for fees back to the first recommendation. So let's say between 2022 and this year, do you remember approximately what the dollar amount is that was your highest grossing month?
Maybe a half hour.
I was paid $52,000 in April after I hadn't been paid for 4 months in a row.
And the most recent tax return that you filed showed that you make approximately $250,000 this past tax year?
230,000. Stan made 350,000, as I recall.
And prior to this past tax year, you actually reported significantly higher income than that, correct?
I had one good year, yes.
Love you, Ralph and Cassie Francis.
That year was about 400,000, right?
Sleep sweet.
Yes.
Okay. Why was your income decreased?
In March of 2022, Stan took my phone. He deleted my text messages, videos. He deleted photographs. He went into my OneDrive account and he deleted files that I had put together for purposes of giving to Dr. Kevin Bird. He canceled plane tickets from my phone. He put spyware onto my phone and onto my.
I'm going to object to lack of foundation. This is not the question that I.
You see how this is responsive. Okay, wait a second. Just stop.
I couldn't do anything. I couldn't do anything. I had to recreate files that Stan had deleted from my OneDrive account. I had to pay to have forensic folks come into my house to find the spyware that he had put into my home.
Your Honor, I'm going to object to lack of.
All right, sustained. Let's stop. Sustained. Ask another question.
I've been diagnosed with complex post-traumatic stress disorder because of the.
Right now, there's no question before you. So, Mr. Dahim?
All right. What I asked was, maybe I'll change it. Did your employer tell you the reason why your income decreased?
I'm a partner in a law firm. I couldn't work because of the stress, because Stan broke my finger and I had to have multiple surgeries and I had to have physical therapy, over 20 physical therapy sessions that I had to go to regain the use of my finger that he broke while he was trying to push me out of his vehicle.
Okay, so I'm going to object to this as well as non-responsive. You're telling, okay, so. So
I'm going to overrule the objection, but we're going to stop the answer and you're going to put another question in front of her.
Your Honor, I'd also ask that any of these allegations that have just been said not be considered by the court, given the fact that we resolved it when we resolved the discovery issue.
No, but you were asking her why her income decreased, and she said it's because he broke her finger and she was stressed. So.
Okay. So you said you weren't able to work because you had post-traumatic stress syndrome?
And because I was recreating hundreds of hours worth of work that Stan deleted from my OneDrive, work files, personal files, I had to recreate them. Have you ever had to recreate something where you have a database?
Ms. Claus, stop.
Hundreds of hours.
Okay, here's what I want to just make sure. You need to listen to his question, answer the question. Ms. Edwards will ask you other questions if there's more that needs to come out. But asking Mr. Dahim a question is totally inappropriate and you know it. So answer the questions that are put before you, please, and keep your answers to the questions that are put before you.
Oh, that eye roll. Oh,
I know we were talking about things that you allege in the past. Currently, you don't have any interaction with Mr. Klaus beyond our family wizard, right?
True.
So currently, you can work, right?
True.
And currently, you can have those good months where you make over $50,000 a year, right?
Yes.
Yes. And you also testified that you and Stan filed taxes jointly this year?
I actually filed married filing separately because Stan refused to file the married filing jointly, but the joint return was prepared. It was sent to both me and to Stan to sign, and Stan refused to sign it. So at that point, Elizabeth contacted you, I believe, and asked you whether or not he was going to sign it and to provide that information by a certain date. He did not provide that information by a certain date, and I filed married filing separately so that I could get my taxes filed, which is one of the conditions of my partnership, that I have filed my taxes on a timely basis.
So I'm confused. I think you testified to Miss Edwards that you filed jointly.
We did not file jointly, but the tax return was prepared. Like I said, it was sent by our accountant to both of us. I signed it and sent it back to the accountant, and Stan did not.
Okay, so your testimony here today is that that joint tax return was not filed.
It was not filed.
Okay. So is it your testimony here that there is not an outstanding tax balance that you owe that's attached to Mr. Klaus?
I'm not sure what you're asking.
Maybe I'm missing something. Why is this relevant? Where are we headed here?
Well, I think it's relevant to just the money issue, Your Honor, with regard to whether or not Mr. Klaus should pay attorney fees. There's several different monetary sources that Ms. Klaus is depriving Mr. Klaus of, and she also owes different monies that's related to this litigation. I can move on if the court's not interested. I'm sorry, Your Honor.
We do. Move on.
Okay. I always like to ask the court because if you're not interested, I shouldn't be interested either. You said that you're satisfied with Travis's service as a parenting coordinator, correct?
Yes.
You don't currently have a sober link requirement on you, do you?
No.
You have not lost parenting time for being late for any particular requirement, have you?
No.
And you're aware that for flowing into the sober link requirement either late or otherwise not timely, Stan has lost parenting time with Mackenzie, correct?
Yes.
How many times during this school year have you gotten Mackenzie to school late?
I don't know.
Isn't it over 90 times last year?
I'm not sure.
Do you remember if it's close to 90?
I'm not sure.
More than 50?
I don't know the answer to that.
Okay. So you can't say yes or no to that, right?
You asked me how many times.
How many times? So I'm asking you, how many times have you gotten Mackenzie to school tardy last year?
I don't know the answer to that.
Okay. And when I asked, is it over 50? You said you don't know the answer. So now I'm asking, is it that you don't know if it's over 50?
Objection,
you
Honor,
just don't know
asked
the
and
number?
answered.
Overruled.
Ms. Klaus, I'm just trying to find out if you can definitively say I have not, her tardies were not above 50.
I'm not, I don't know the answer to your question. I'm sorry, I don't know the answer to your question. I mean,
That's
seems
all.
to
That's
me
all
you-
right. I'm just
Do you
I'm just
have,
trying to figure
you can
out.
look that up on their website, so I'm not sure why, I don't know the answer.
Okay, I'm just trying to figure out the scope of your knowledge. So I understand, and my questions might not be the best, so that's okay. Um, so maybe I'll do this and then I'll move on. Is it possible, within the realm of possibility, that she's been tardy to school over 50 times last year?
I don't know the answer to that. I'm sorry, I don't know
Okay.
the answer to that question.
It's okay. You don't know the answer. Let's ask another.
That's all right. And you've never lost parenting time for any tardies or anything like that, have you?
No.
That's all we have, Your Honor.
Redirect.
A little bit, Your Honor. Kristen, you stated that you are paid on, you're only paid on revenue in the door. When did that arrangement begin?
January of 2023.
Okay. So you indicated you got a payment, where did my notes go? That you got a payment in April of 2023, and that you, to be clear, that was the first payment for 4 months?
That's correct.
Did you get a payment in May?
Yes.
Was that, how much was that?
I don't know off the top of my head. It was less than 50.
Okay. Payment in June?
Yes.
More or less than 50?
Less than 50.
Was it, you stated in November of 2023, you got paid $20,000.
Yes.
What was the June payment more, was the June payment more or less than $20,000?
I believe I'm trying to answer. So Taft essentially made me pay back my salary from 2022 because I just wasn't able to do any to work like I had because I was so involved in trying to get the spyware out of my house and off my computers and trying to recreate the things that I had recreated, spent hundreds of hours working on this. So Taft essentially made me pay back the salary that they had given me in 2022 before they would pay me in 2023. And so it took me until April to pay back the deficit and the difference of my compensation. And then Taft did give me a number of payments in April, May, and June because I had a lot of revenue come in at that point due to some closings. And so I don't remember exactly how much it was in total in June. I think between April and July, I was paid a total of around $120,000 between April and July. But then after that, my typical compensation is somewhere around between $16,000 to $25,000 during the month. But like I said, in October, I didn't get paid anything. So by the end of this year, my total compensation will be around $230,000. I also lost equity in the firm, so I don't get any distributions. I'm a partner, but basically in name only.
Nothing further.
Cross.
One question. So based upon your statement that you typically make between $16,000 and $25,000 a month, that means annually you make between $192,000 a year and $300,000 a year, correct?
Again, it's dependent upon revenue in the door. This is the first year that I've been compensated in this way. And I really have no typical way of understanding what I'm going to get paid next month or the month after that or the month after that. It's all based upon when my clients pay their bills, if I will get paid at all.
Your Honor, I'm not going to belabor the point. That's enough for us.
Okay. All right, any other witnesses? Ms. Edwards?
No, Your Honor.
Okay, then let's do this and let's do it in a kind of as organized a way so I know what issues I have to deal with. Because right now I'm not sure I do. How about that? So I'm going to start with you, Mr. Dehem, and I guess I'm asking you what you want, and let's just take it one thing at a time. And then I'm going to have Miss Edwards kind of go through what she wants one thing at a time in response to your one things at a time.
All right, Your Honor. I'm gonna have to write it down myself. There's a lot going on. I think first and foremost, Your Honor, we would like the removal of the supervised visitation requirement. At this hearing, there's been no evidence of endangerment whatsoever. And regardless of whether or not there is an order, the first recommendation became binding, became an order one way or the other. The fact is that there is no evidence of endangerment. This would be overturned on appeal immediately. So we would like that immediately removed, especially given that we have the Christmas holiday. Mr. Klaus has already lost months of time with this little girl. The second item we're requesting is the removal of the sober link requirement. There has never been, and I think Mr. Klaus was clear, maybe more so than I would have liked him to be, that the only reason SoberLink is in place is that he signed this agreement, which he believes he signed it under inappropriate circumstances, but there's no evidence that he's ever had an alcohol problem, and instead he's, if anything, he has a timing issue, which a busy person does. I think just because I'd like to give the court different options. Obviously, if the court would want to first have him undergo a substance abuse evaluation, that's something that he said he would do. Even if the court wants to keep SoberLink, I think we have to find a way to increase the time frames from 30 minutes to maybe a couple hours, or something that just demonstrates that he's not, where he can just prove, hey, I'm not drunk, I don't have any alcohol in my system, rather than having to undergo these technicalities, which frankly hurt the child here. We're also asking for the removal of Travis as parenting coordinator. I understand that he has different reasons for doing what he's done. However, he's overstepped the order. I don't think in his mind there's anything he cannot do as parenting coordinator. He's exercising judicial authority, and especially in this case, it's very clear that he's not going to get anywhere, given the emails that he sent and the animosity that even he expressed in those emails, especially given the fact that he's going to have a conflict and currently does have a conflict given the payment issue. Mr. Klaus is very clear that he will pay and work with any future parenting coordinator. And I'm going to represent to the court right now, let's say that he reneges. He knows full well that the court is going to throw the book at him then, because that means what he's representing now is not true. So he's aware of that and he's ready to go forward. We're also asking that the sanctions, the $500 sanction issue that Mr. Van Winkle put forward, be removed. It's overly punitive, does not consider the means or financial status of the parties. We are asking, let me consult my list, I apologize. We're asking that with regard to the bank statements issue, Mr. Van Winkle in the PC order is not permitted to resolve significant financial matters between the parties, but he has requested all bank statements. I think he even said that he probably doesn't need them anymore. And, obviously, if he needs to resolve a small issue, he can just ask for the transactional issues. He doesn't need the bank statements. And if anything, it shows that there's even more of a conflict here. We are also asking that the court issue an order awarding Mr. Klaus his attorney fees, and will submit evidence of those attorney fees through affidavit within 10 days after the order is issued. Mr. Klaus essentially has had to fight to get his daughter back because she was removed due to a timing issue, not because of any safety issues or anything like that. And I'll be the first to say that he gets excited, he gets frustrated, and I can't say that I wouldn't be frustrated too. As the only person here that's not an attorney, he probably understands the least, but I can guarantee that he loves his daughter and his daughter is 100% safe with him, and he shouldn't have to continually pay for SoberLink, pay for supervised visitation, when all of this could have just been resolved. Ms. Klaus knew and testified that she knows that all of this is just due to a scheduling issue, to blowing outside of a 30-minute window, and there was no attempt whatsoever by Ms. Klaus to present any evidence of endangerment. And this is just a travesty, to be honest. A little girl lost her father for months because of a 30-minute window.
All right, Ms. Edwards, I don't know if you have things you're asking for in addition to that, but can you address all those things in that same order?
Sure.
To start.
Sure. Your Honor, at the end of the day, all my client has wanted is for Mr. Klaus to follow the terms of the decree. The decree that he signed with counsel at mediation after a long day of mediation. I believe I will give Mr. Dehem some grace, given that he is the second attorney on this case with for Mr. Klaus. We had a full custody evaluation.
The lawyers beat you
Had
to
the
it, Philip.
SoberLink testing been so out of bounds, I believe that, all of us in this room who are familiar with family law know Dr. Kevin Bird and know that he calls it like he sees it. If he believed—
Your Honor, I'm objecting. None of this can be considered. None of it was presented. We can't, counsel is testifying to information that was not provided at the hearing.
Your Honor, Mr. Dehem said, he referred to his list as more of a closing argument and said there's been no evidence of an alcohol issue. There was prior evidence of an alcohol issue, which is why SoberLink got put into place and why it was part of the custody evaluation, and why there was also a clear step down put into the order.
Jesus.
Your
Honor, we're talking about evidence that may have been introduced at a prior hearing or may have been, provided to the parties. If that evidence exists, it should have been presented. Instead, we're having counsel talk about it. It's not. There's none of this is admissible. If there was an issue, it should have been provided.
I guess what I would say is, Ms. Edwards, all of that got you to the point where you have an agreement that is requiring SoberLink, I suppose. I mean, I don't see SoberLink in every settlement agreement. And I think what Mr. Dehem is saying is there was a few time issues, but not intoxication or impairment or positive test issues. I would say at this point, we're looking at the period of time since this agreement. But I know, I'm looking at this agreement, it calls for SoberLink.
Yes.
I mean, how many agreements do I see like that? I don't see a lot.
Yes, and so, Your Honor, I'm just addressing I believe what he's saying right now, as we sit here right this second, there was no evidence presented in this hearing of an ongoing alcohol issue. I'm just responding to him, any suggestion that this SoberLink came out of nowhere, but I'll leave it there.
Okay.
So my client would like him to simply follow the terms of the agreement that he agreed to. He's able to get out of this SoberLink with 60 days of testing. Absolutely, we would 100% support the substance of abuse or use evaluation that Travis previously ordered. Absolutely not. We do not agree to increase time limits because one of the issues in this case, Your Honor, is that the 1 o'clock test was put in place at that time so that there would be clarity that Stan was not using alcohol before he began his parenting time after the child got off of school. So that's.
I apologize. I hate objecting to closing argument, and I apologize. It's a bad form. That information was not testified to either. So I understand that Miss Edwards may have what she believes is an understanding of what occurred before, but that wasn't talked about, the 1 o'clock test or anything like that.
Okay, I thought we did talk about a test that would be after like at the time that, because I remember thinking about this, I had right after I had your case with you guys, I had another case, and it was very helpful what we had been through with SoberLink, all that information I got that day. But I thought we did have that discussion that Travis did testify with regard to that.
I think he testified. I think he testified to the timing, but not the reason for any additions or anything like that. But if you remember it, then I'm going to go with
I
your memory.
remember because I thought, oh yeah, I remember going, oh yeah, that makes sense. Go ahead, Ms. Edwards.
Thank you, Your Honor. I'll leave it there with regard to the time limits. We don't agree to increase them. Every case I'm involved with that has SoberLink has a 30-minute window. We don't agree to remove Travis's PC. I do think, I mean, again, it costs a lot of money to get a new PC involved. Certainly, if this court decides to remove Travis because Stan no longer wants to work with him, we would request that Stan be responsible for paying the fees for the new PC to get up to speed, which means reading all of these voluminous pleadings and having intakes with the parties. We would request that all of the recommendations as filed by the PC be made orders of the court. We have no objection to any of them. Additionally, Your Honor, there's been, again, I see no reason why Stan should be awarded attorney fees for his desire to object to three of the recommendations and request the new PC and request to modify his parenting time. So. And my client would request attorney fees for having to try to enforce the recommendations, which are to enforce the order.
Okay, I'm going to make a ruling with regard to the supervised parenting time and keep the SoberLink in. I'm going to remove the supervised parenting time. There is no basis. I mean, there's just not sufficient evidence of endangerment. I mean, that is an extreme remedy, and I just don't think it's there. I mean, I'm gonna order that his parenting time resume as was in the original agreement. I'm going to put the SoberLink in place for the moment so that I kind of keep a status quo, and I'm taking all other issues under advisement, requesting proposed orders from the two of you. And the sooner you can get them to me, the better. And I would really like to do this. I'm not having any court sessions between the Christmas and New Year's, and I'm trying to get caught up on orders. So I'm working, but I just don't have court. So I would love to work on this then. And so if you could get it to me by before Christmas, right before that Christmas break, I would appreciate it. But so that's, what is that date? I don't even know. December 21st, I think 23rd. We have Tommy, do we have a half day on the 23rd? Is that what we got? I mean, it's not like I can't. I got access to it all.
Understood.
But I want a deadline for that.
Half days on the 21st.
Okay, that's what I thought. Okay, so can you get them to me by December 21st at noon?
Yes, Your Honor. Yes, Your Honor.
Okay. Now, here's what I'm going to say so that we can move forward through. I want to write this order as soon as possible because I fear that any delay in writing it, there'll just be more things coming in on top of it. And that always it confuses my brain. So moving forward, I want to say to you, Mr. Kloss, that I know you've struggled with time, and we talked about ADHD, and there's so many ways to kind of deal with that, whether it's setting alarms on your phone. I mean, I sensed at times maybe you just didn't want to walk out of the gym and do it, or that you don't like that process. And I don't blame you, I don't blame you. But right now, that's where we are, and we want to get through this period moving forward with the least conflict as we possibly can. not necessarily for you or for Kristen, but for Mackenzie.
I guess the sober link was getting in the way of leg day.
The whole issue with regard to keeping Travis on as the parenting coordinator, I figure that once I look at your proposed orders and I start writing, it's all going to come to me. I'm struggling with that because I don't know whether he's overstepped or not, but clearly there's been a breakdown in the relationship. So how can we move forward and with the owing of money? But on the other hand, it is going to be a big process for the new person, should I say that, to come up to speed, and it would be an expense. And I think, Mr. Tahem, you're clear that if I do that, that expense will be attributable to your client. One other thing I wanted to check on this. Hang on a minute. It's lists, for goodness sake.
This is an awesome announcement, guys. As if this case wasn't clusterfucked enough.
Am I a special judge on this case? Was I appointed special judge? I should have a flag. I can see a flag.
I believe so, Your Honor.
And they didn't put it on my list. Okay. So just so you're aware, I'm leaving the family division and going to the criminal division at the end of January. And so I'm just letting the attorneys know, and I guess the parties know too, that I can't keep all these special judge cases and be kind of have one foot back in family, because you just can't function that way with the time requirements of these hearings. So I am going to be recusing myself on this case by the end of January, clearly after I do this order. And you'll have the option of leaving it in court 15 for the judge that will be newly assigned. We don't know who that is yet. Coming to an agreement as to another judge in the family division, or going through the process under the trial rules. So just want to make you aware of that.
So she's going to write up the order and kick it off to somebody else's lap.
Okay. That's why I want to get this order done as soon as possible.
Your Honor, if I may, and I know this is a little out of the ordinary, but I'm going to go to sleep tonight wishing I had said it if I didn't.
Okay.
I would like to just give a quick reply to the closing argument by Miss Edwards of 20 seconds. And what I mean is, this litigation never would have been necessary had it not been for the supervised visitation. That's the issue. Had that not occurred, Mr. Klaus would not have come to court. And you didn't hear any argument from Miss Klaus or her attorney against supervised visitation. They could have recognized that there was no danger, agreed to lift that requirement. There was no need for us to be here at all.
I mean, obviously there's a long history with this family, and there's nothing I can say. I mean, it's unfortunate that they've chosen, both of them, to live this way. That's all I really got to say about it. It's really unfortunate.
Yes, it is.
But it's both of you, really. Okay.
And with that final slap in the face, the judge cut the stream. So I don't know if I'll be able to catch the next hearing or not. I don't know. That's one of my grab bag dockets that I don't know what I'm gonna get. And it's impossible to follow cases. So, but that was so worth it, even though I didn't have the whole thing. I'm sorry I wasn't able to get it all, but that was still worth it, I think. Yeah. Yeah, I get, I don't know, like Lorena Bobbitt vibes from her or something. She was something. Yes. Yes. It's truly a choice to live that way. Well, okay. Here's the thing. The husband had gone through one other attorney that had withdrawn or was fired, one of the two. I don't know if the female did or not, but they have a parenting time coordinator kind of person. I don't know. It's like I guess it's somebody appointed by the court, I would think. It sounds similar to guardian ad litem, but they were talking about that person overstepping bounds and things like that, doing things they weren't supposed to do, and calling shots and things like that. But now they want that person off the case and to have a new one of whatever that was appointed. And now the judge is recusing herself. Yeah. That was, yeah, and that's that's what Paul Meyer and I were both hinting at too. Yeah. Aw. Everyone wants to see you succeed, sweetie. She's basically the same, but she's got underscores under her first and last name part. Go ahead and throw the link back up, Lisa May. I have more that I can play. It's my 1,500 subscriber day, so I am not done. I am going to stay on and play some more. Oh, let's see. Ooh.
If you can hear me, I want to start with Mr. Harris.
Yes, Your Honor, it's coming right up.
Thank you.
It's Wyatt.
What's going on here? It sounds like we're having some competency issues here.
Yes, sir. This started back
in 2020. That's all I know.
Yeah, started in 2020. I had him evaluated back then by a Dr. Dunham. He was found incompetent. Mm-hmm. At that same time, because I know Dr. Dunham pretty well, he's like, "Hey, you need to get this guy evaluated for insanity." Because I'm telling you, it's just kind of textbook. So we went through the process of him getting restored. He just had a hearing. He was found competent. Later this month, I've got an appointment for the insanity defense stuff.
Okay.
So that's kind of the background there.
Okay, so then let's just, so this is Mr. Travis Harris. Basically, he's here on a charge of aggravated robbery from 2020. I believe his bond is $300,000. Okay. All right, Mr. Wyatt, go for it.
Yes, sir. This is Mr. Travis Harris. He's 40 years old. His mother lives in Dallas. He's a U.S. citizen. He attended college in Mesquite, Texas. He's also earned his commercial driver's license. He is a truck driver. He graduated from honors in Atlanta, Georgia from high school. He was living with his mom in Dallas. He has 3 children, 8, 17, and 19. Judge, in this particular situation, my client does have some mental health issues. He has got a long history in San Antonio. He is not from El Paso, Judge. He was, in the instant case, he was coming from California, and he had a passenger with him, and the passenger testifies that my client was having some mental health issues, that he thought people were following him, and that people were after him. That went for a long time until he got into an altercation on the freeway. He took some lady's car. She tried to resist. He drove away. He has been fully restored, and I understand what the court's issues are going to be, Judge, because when he has those kind of episodes, it seems like something bad does happen. But after already talking to the doctor, I'm pretty sure it's going to be insanity. The guy's got an absolute defense. He has been restored. So I would, I know he can't get a PR bond, but if he could get a bond where he could afford to get out, I would, I know he'd really appreciate it. He's been in there for a long time, Judge.
All right, Mr. Loving, just briefly, criminal history prior to these matters.
Yes, Your Honor. I see a theft in Dallas. PG1 less than a gram. He got deferred. Another PG1. An evading. Looks like a possession of marijuana. AFV from Dallas. And that's all I show, Judge.
All right. Let's go briefly over the facts of the case, please.
Yes, Your Honor. Officers were dispatched to I-10 in Piedras, found a female, the complaining witness, lying in the middle of the roadway. She was driving a white 2003 Mitsubishi Montero when her vehicle collided with a moving truck, which she describes as a large white moving truck. She pulled over to the side of the highway. A black male, the defendant, got out of the white truck. He opened her door. She thought he was going to ask if she's okay, but he pulled her out of her seat using force, attempted to sit in the driver's seat, drove her vehicle away. As Mr. White said, there was a passenger in the defendant's vehicle who gave a summary of the facts and stated that she did see the defendant take off in the victim's vehicle, almost running her over. The victim was treated at the hospital, suffered cuts on the back of her head, a hematoma to the scalp, and some abrasions to her face, Your Honor.
Right. All right, 300,000. I'm going to put it at 75,000. That's the ruling of the court.
Thank you, Judge.
I absolutely adore the defendant. He reminds me of John Coffey. If y'all have ever seen The Green Mile, he really, just look at him. He's John Coffey's little brother. How can you not love him?
All right.
I'm sure the lady in the car didn't love him.
I will call your mom, let her know.
All right, I need to speak with you as soon as possible, too.
Absolutely.
Yes, sir.
Thank you, sir.
Bye-bye.
All right, downtown, who is this?
Josh, this is Chacon Carlos.
Who's got him?
I do, Your Honor.
All right, let me see. So Mr. Chacon is here on a charge of smuggling of persons. It's a rehearing. His bond is currently set at $30,000. His original attorney was the public defender's office. His original attorney is the public defender's office, Ms. Martin. Let me just check something real quick here. Okay, sir, you speak English, okay?
Yes.
All right. Go ahead, Ms. Martin.
Your Honor, my client is an 18-year-old U.S. citizen. He is a graduate of Burgess High School. He was attending the El Paso Community College before this incident, Your Honor. I spoke to his mother, and she answered the phone within 2 rings, and we had a very long conversation.
The answering the phone within the 2 rings, that was super important information.
She would like her son to return to their home at he lives there with his mother and his father and his 3 little brothers. They have absolutely no funds to bond him out, and they are requesting that he be released so that he can continue his studies at El Paso Community College. I do have her telephone number. She said anyone from the court can call her to verify that she does want her son home. Nothing further, Your Honor.
All right. Mr. Loving, no criminal history, right?
Your Honor, there is an arrest from 2022, federal transporting aliens, but that's not a conviction yet, as far as I know.
Okay. Is he out on supervision? Listen to that case, Ms. Martinez, as far as you know?
What, John? I'm sorry. This is the only case that I show he has.
Okay, no, because apparently on the rap sheet, they show an arrest with the feds last year for something similar. What I want to know is if you know if it's still pending or it's been disposed of.
I don't know, sir. I didn't even know he had that.
Yeah. All right, so this is just a proverbial defective license plate. I guess they run. I mean, I guess he had a. Is there? No, you know, there's some component of evading here, right, Mr. Loving?
Yes, Your Honor. It doesn't describe how fast he was going, and it seems to be a short distance on I-10. Exited at Mesa, got back on the freeway, and then stopped once he was back on I-10.
I'm going to do significant reduction, but it's not going to be a PR one. It's going to be 2,500 on the case. Okay, thank you.
Thank you, Your Honor. He's my only client today. May I be excused?
Yes, ma'am. Thank you.
Thank you, sir.
Judge, just to be sure, you said 2,500, correct?
2,500.
Okay, thank you.
Okay, keep in mind, they can see you and they can hear you.
Okay, sir, what is your name?
Hector Ayub.
Last name?
Hector Ayub.
Ayub, okay. Let me see. All right, Miss Solis, this is your client, right?
Yes, Your Honor. Is this Hector Ayub?
Yeah.
Perfect. Yes, Your Honor.
All right. All right, sir. So this afternoon, you set for a bond reduction hearing. Okay, you have a charge of smuggling a person's third-degree felony with a bond of $30,000. Your attorney, Ms. Solis, is going to present evidence to try and convince me to give you a lower bond. Then I'm going to hear from the prosecutor, Mr. Loving. Then I'll make my decision as to what happens to your bond. Go ahead, Ms. Solis.
Yes, Your Honor. My client has been a resident since 1998. He's 41 years old. He has worked for Uber for over 2 years. All of his family resides in El Paso. He's currently residing with his mother, Ms. Rosa Adame, and his stepfather, Mr. Adame, at 207 South Maryland in El Paso, Texas. He is currently under the care of Emergence, where he receives medication for anxiety, bipolar, and depression. Judge, I did check. There's no ICE hold. I need to do a little more investigation, Judge. According to my client, this happened as a result of an Uber pickup. He does have dash cam in his vehicle that will be made available later if this case goes to district court. He also has communication where he was sent to pick up these individuals at a hotel location. And
y'all, could you imagine driving for Uber like I used to do, picking up a group of people and then getting arrested for transporting illegal aliens?
And I believe the location that I'm changing, but he does have messages that we do plan to produce showing that he had messaged Uber regarding this pickup, Judge. The bond is currently set at $30,000. We would respectfully request if the court could consider a $5,000 cash surety or lower cash surety portion. Family does not have a lot of money with PR conditions, Judge, if the court wants to impose those.
Mr. Loving, criminal history?
One prior DWI, Your Honor.
I read the facts. Okay, it's 2,500. That's the ruling of the court.
2,500 cash surety, Your Honor.
Yeah.
Thank you.
All right.
Okay, may I be excused?
Yes, ma'am. Thank you.
Thank you, Mr. Loving. Thank you, Judge.
All right, Judge, we're moving on to the following floor with Santoyo.
Okay. It's called the trickle effect. You know, start with a lot and then boom, boom, and then one, you know. All right, recess again, guys. All right, so we have now left is Mr. Santoyo. All right.
Okay, Judge, my apologies for the delay. He's here, he's ready.
All right. All right, Mr. Santoyo, you're here because you're scheduled for a bond hearing. Okay, you have a felony charge of criminal mischief with a $5,000 bond. Your attorney from the Public Defender's Office, Mr. Gavaldon, is going to present evidence to try and convince me to give you a lower bond. Then I'm going to hear from the prosecutor, Mr. Loving. Then I'll make my decision. Go ahead, Mr. Gavaldon.
Thank you, Judge. Mr. Santoyo is a U.S. citizen from El Paso. He's met with our social worker to develop a post-release safety plan. The main one is to be seen by EHN Takumi to be screened. Although the allegation here is that there was criminal mischief at EHN, so I know that might produced some conflict with the court for some mental health screening. We were able to confirm his address. That's what he told us, and that's what we had on file, though we did contact his mom and weren't able to get that assurance from her. She just didn't answer her phone. So though we've been able to look at some other info to confirm that's his address, we weren't able to speak with her. He does have some mental health diagnosis. He was previously receiving some care out in Colorado, where he was living about 3 months ago, from the Highlands Behavioral Health Center up there in Colorado. And again, Your Honor, he's got no money to post bond. He denies any need for substance abuse help, although he was and would like to be and has been referred to Texas Workforce Commission with help on getting job placement skills, and then also to complete or start trying to get his GED. And so any reduction will be greatly appreciated. He's got no money to post bond, Your Honor. Thank you.
Mr. Lovin, criminal history?
Your Honor, the rep sheet shows no other offenses than the one in front of the court today.
Let's go briefly on the facts, because I know this happened at emergency, when I think he took a swipe at, I think it must be a doctor's car or something like that, based on the amount of damages that I saw in there. It's a BMW, I think, if I recall correctly. Let's go over the facts, please.
Yes, Your Honor, we have a 2009 Mercedes S series. Reporting party observed the defendant striking the vehicle with a rock, caused damages to glass windows, the roof of the vehicle with a large rock, estimated to be $20,000. Officers responded, found the defendant walking eastbound on Montana, matched the description from the call, detained him, took him back to the scene where he was identified by the reporting party, who is not the owner of the vehicle, Your Honor, but he did see the defendant damaging the vehicle.
2,500, that's the first the court's going to do.
Understood.
So trial counsel, get him to a trial court, because you guys can get some sort of a disposition. Because I don't think, I have my doubts that he's going to be reporting or calling Pierre Havana he's supposed to. So right now, 2,500, that's the best the court's going to do. Thank you.
Understood, Judge. Thank you.
Mm-hmm.
That's all I have, Your Honor.
I think we're done. We're done. Officer, that's the last defendant, right?
That's right, Judge.
All right, then everybody's excused. Thank you.
Thank you.
Y'all tomorrow.
All right.
Thanks, Judge.
Thank you, Judge.
Thank you, Ms. Martinez. Good seeing you.
Continue.
That was fun. I just love Attorney Wyatt. I had to do it. Hey, Tiana Miller. Welcome to the 1,500 subscriber stream. Good to have you. So, you guys want one more? I have, let me see what I got. I have a really crazy breakup. I have another really crazy breakup. Man, I've got a few really. Oh, I like this one.
The District Court of Greenwood County, Kansas, case entitled City of Eureka versus Jeremy Ray Austin. It's case number 2023 CR 100. James Watson appears for the City of Eureka. Marianne Shirley is counsel of record for the defendant, Jeremy Austin. Jeremy Austin does not appear. The court's docket notes indicate that there was a previous proceeding scheduled in this case for October 12, 2023. Mr. Watson appeared. Ms. Shirley did not appear. Jeremy Austin failed to appear. The court ordered forfeiture of the $259 appeal bond for the failure to appear, and the case was reset to today's date. The court is aware that Mr. Austin's had telephone communication with the court's administrative assistant. Apparently, he explained that he had received notice of the hearing, but apparently got this case confused with perhaps some other court date that he had. Is that a fair assessment, Mandy?
Yes.
Okay. And apparently he was in communication regarding this particular court date, and again, he doesn't appear. This matter does need, I trust that the whole idea of this matter was appealed so that the defendant could exercise his right to a jury trial, Ms. Shirley?
That's correct, Your Honor.
All right. Well, I'm going to go ahead and let counsel know that I'm going to go ahead and establish this case on a future docket. My hope was we could actually get this tried next week. But with Mr. Austin's failure to appear, I think the only realistic thing to do is to set this case on the court's next Greenwood County date and work toward that date. That trial date is March 19 of 2024. March 19, 2024 for jury trial start. I will establish a pretrial conference the week before. That would be March the 13th. And I'm contemplating 1:15 p.m. Now, the pretrial conference, I'm contemplating to be done by Zoom at this point. Obviously, the jury trial's in person for all stages, if it goes. I know it's always a bit tenuous when I don't have the defendant on the meeting. The court's going to order a bond forfeiture again and issue this time a bench warrant for his arrest, with him to be held on a no bond hold pending further proceedings of the case. Mr. Austin cannot just pick and choose when he appears or contacts the court. He needs to appear for all scheduled court dates. He's triggered district court jurisdiction by filing this notice of appeal and challenging his municipal court conviction. And I expect him to be on each and every Zoom meeting that we have regarding the case. We never gave him any indication otherwise.
Judge Ricky, he is on the phone now. He's been trying to get in. He said he couldn't get in. He is on the phone with me now.
I don't know what it means for him not to get in. Mandy, has he tried to join this meeting?
No, he has not.
All right. So I'm not sure what he means by trying to get in.
Okay. All right. The judge said that you haven't tried to get into this hearing.
If he'd put in the Zoom numbers and tried to join, he should be at least in a waiting room waiting to be let in.
Okay. All right. Here, let me give you the number to get in. Okay. Right now. Hurry. The judge is pissed. Bye. He's going to try again, Your Honor.
Were you appointed or retained on this case, Ms. Shirley?
Retained, Your Honor.
All right. Jeremy Austin? Jeremy Austin? Mr.
Jeremy,
Austin?
there you go. You just muted.
Right, I'm not hearing you. Is your speaker volume down?
Jeremy, can you hear us?
Randy, if you can give him any chat instructions, please do.
How about now?
I can hear
Hello,
you now,
hello.
Mr. Austin.
Okay.
Mr.
Sorry
Austin,
about
you
that,
would
sir.
have been on this meeting at 12 minutes ago. This is scheduled for 10:30.
I'm sorry about that, sir. I've been on the phone. I don't know if I would want to divulge this stuff over this. My phone has been hacked. My messages are being rerouted. I can actually prove that to you. Things are being sent in code. I'm sorry. I don't know what to say about it.
Mr. Austin, your attorney has announced that you still intend to seek a jury trial to try this case. And I've set court dates, which you need to write down. You got something to write with?
Yes, sir.
Okay, you've got a Zoom pretrial conference on March the 13th at 1:15 p.m. That's March 13 of 2024, 1:15 p.m. Mr. Austin, due to your tardiness and fumbling with technology this morning, I'm going to require you to be one of two places for the pretrial conference. You need to be in Ms. Shirley's office, or you need to be at the Greenwood County Courthouse. The sheriff's office very effectively maintains a Zoom location there. I never have any technology problems from the judicial centers. So you'll either need to be at the courthouse in Eureka or Ms. Shirley's office in Eureka.
Yes, sir.
Time. So we don't have any of these problems again.
Okay.
The court will set aside its previous order regarding immediate issuance of a bench warrant for the defendant's failure to appear. I'll take under advisement the forfeiture of the bond, which I've already ordered pursuant to Mr. Austin's failure to appear on the 12th of October. For now, that order stands.
My birthday.
And we've set new court dates for pretrial conference and jury trial. Mr. Watson, have there been any efforts to try to resolve this case by plea at this level or some other type of disposition?
I would be happy to speak to Ms. Shirley about it.
Well, the court's going to direct counsel to at least confer about this, find out if there is any common ground here. If not, obviously, we've got our pretrial conference and jury trial dates set. If there is some sort of agreement regarding a disposition, I'm certainly open-minded to moving up any further hearings on disposition and not necessarily waiting all the way to March. This case has already been pending in this system, in the court's view, way too long. All right, Mr. Austin, do you have any questions about what we've done here this morning?
No, sir.
I highly suggest that you call Ms. Shirley either immediately after this hearing or as soon as you can. I think that she probably needs to talk with you, and you would benefit from having a conference with your defense lawyer. And I trust you know how to get a hold of her, right?
Yes.
Okay. Mr. Watson, is there anything further that the court needs to pursue at this time?
Not to my knowledge, Your Honor.
Ms. Shirley, anything further currently?
Nothing. Thank you, Your Honor.
Very well. Then the Jeremy Ray Austin matter will currently be in recess.
That one was too much fun, y'all. When he said his phone was hacked, I was like, you've got to be kidding me. But he can prove it. He can prove it, he says. So, I probably should have mentioned this a lot earlier when there were far more people on, but I know a lot of people are going to be watching on Replay Crew as well. My time slot of YouTube being mean to me, remember, January 2nd is how long I have to go still until YouTube monetizes me. So, by no means, I don't ever expect anyone to donate, but if someone is able to throw something to support the channel, my Cash App and PayPal and Venmo are always in the descriptions of the videos. So if you guys are able to, I know it's that season and it's tough for everybody right now. But just wanted to throw that out there. So, like I said, I'm going to keep doing this, monetized or not. But I've got quite a ways to go until YouTube stops being mean. Even though I've hit 1,500 subscribers, YouTube doesn't care. Yes, and if you're not able to do anything monetarily, that's fine. But please, please, at least hit the like button, share it, make sure you're subscribed. Those things really do help. Throw comments in the comments section. Help, swing the algorithm. Oh, you going to sleep, Philippines? Thank you, sweetie. Thank you for coming out. Let's see. I'm going to stay in Kansas, y'all.
Good morning. Morning, Judge. I'm assuming that's Mr. Ashdown in your office with you? That is correct, Your Honor. All right. And are you Janine Baumberger?
Yes, sir. I am.
All right. Are we expecting anybody else this morning?
I don't believe so, Your Honor.
All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled in the matter of the marriage of Melbourne Ashdown III, petitioner, and Janine Ann Baumberger, respondent, 23 DM 301. Petitioner appears with attorney Richard Paw. The respondent, Janine Baumberger, appears pro se. All parties are appearing by Zoom. We are set today on a motion for contempt. Any announcements to make at this time, Mr. Paw?
No, Your Honor.
All right. And Ms. Baumberger, by your appearance here today, I'm assuming you received a copy of the motion in order to appear?
Yes, sir.
All right.
And Judge, just for the record, she was personally served on November 16th by our processor. And that has been filed with the court.
Okay. I don't have that here in the file, but I figured that was the case. So, all right, Mr. Paw, you may proceed.
Thank you, Your Honor. Your Honor, this comes down to Mr. Ashdown wanting his personal items in the house. We filed for divorce back in August. And on August 8th, there was a temporary order filed. And with that order, there was a list of items that Mr. Ashdown wanted out of the house. And he is still to this day has not been able to receive those. Just to let you know, Judge, the divorce has not been finalized yet. The respondent has not has not filed an answer or retained counsel in this case. What we do know subsequently is Mr. Ashdown went over to the house on multiple occasions to try to retrieve his items. Mr. Ashdown lives in Butler County. The respondent lives in Eureka. There were multiple incidents where Mr. Ashdown tried to get assistance from the Greenwood County Sheriff's Department. In all honesty, they were not very cooperative with him trying to retrieve his stuff. Mr. Ashdown actually drove by the former marital residence one day, and there was a pile of his stuff out in the yard with a big sign that said free, and asked me about the boat motors. Judge, Mr. Ashdown believes that Ms. Bumgarner has sold the boat motors. He values them at about $1,000. Also, there was a neon sign that he had that was broken by the respondent. It's going to cost him about $400 to get that fixed. He's in the process of doing that. The respondent has not basically helped Mr. Ashdown get his personal items out of the house. And one of the things is his brother's ashes. So, I mean, and he had within the temporary order had made a list of all of his personal items that he wanted out of the house. And he, like I said before, Judge, he tried to do it. At first, he tried to do it, the amicable way. Then he sought law enforcement help. Neither one of those were very helpful. He's gotten minimal items out of the house. And Judge, we would ask that you find her in contempt. I have approximately about $400 in attorney's fees in this action, and in our motion, we ask that she pay that. Also, if she has sold the boat motors, Mr. Ashdown, those were his personal items. He wants compensation for that, as well as to repair the neon sign. So, Judge, that's where we're at today. At the end of the day, Mr. Ashdown just wants his stuff back. He wants the divorce to be finalized, and he wants this all to be over with. So that's all I have, Your Honor. Thank you.
All right. Thank you, Mr. Paw. Miss Baumberger, your response?
Well, Your Honor, I took the free sign down off of his stuff. I wasn't aware I couldn't do that. So as soon as I found out, I took the free sign off of his stuff. He has been to the house twice. The first time was the day that I got served his papers. And then he had told me that he'd be back the next day. He didn't show up until like days later. I was at work and I came home and I was at work and then one of my children came in and told me that he was there and that they had that the cops had advised him that he could not go into the house if there wasn't anybody there. I was at work. I didn't even know he was there until one of the kids called and told me that. I wasn't going to leave work just because he showed up. I mean, I had been sick and I couldn't just leave work just because he was there. So when I got home, he was still sitting there and I checked on the animals and I left again. And I have not heard, he's not made contact with me to try and come and get his stuff since then.
She checked on the animals and then left again without letting him get his stuff, and then put his stuff out on the curb with a free sign and thought, that's perfectly reasonable. I didn't know I couldn't do that.
As far as the boat motors, they were garbage. They've been sitting outside for years and years. So they got thrown away with the other pile. They got taken to the dump with the other pile of trash that he left in the yard. They got taken to the dump. As far as the sign goes, I was not aware it was broken at all. It was not broken when I put it in the bedroom to store his stuff.
It was not broken when I put it in the bedroom to store his stuff. So you broke it. So you are responsible for it. That's how that works.
And I have not heard from him. I had not heard from him in almost 2 months. He's not made any mention about trying to come and get his stuff again. And as far as getting into the house, that's one thing. I understand that. But he's still got the boat motor, the boat's still sitting there, 2 toppers, the car's still sitting there. He's still got stuff in the garage that he could get out. He's made no attempt to come try and get any of that stuff. And I don't feel that I am in contempt because he's not made, those 2 times was the only times that he's made any mention or even tried to come and get his stuff since I got the paperwork on that issue.
All right, so Miss Baumberger, you received the copy of the temporary order with the list of the items, is that correct?
Yes, sir.
And those items are those, where are those items?
Most of them are in the bedroom or in the house, like his brother's ashes. I still have his brother's ashes. I'm not going to do anything with them. I'm not going to just like keep them from him. I was planning to, if I saw his brother, making sure that his brother got them. So I didn't have to have contact with him if he didn't come and get them before I saw his brother. I'm not trying to keep his stuff from him.
So your position is you have all of these items, you're willing to return them?
Yes. The only thing that there are a few things that I am in contention with on the list. I did not realize I needed to, on the divorce, I did not realize I needed to do a response. And I haven't been able to attain an attorney. So I just financially cannot afford that right now. As soon as I can, I was planning on getting it taken care of.
So much BS.
Well, what items are you?
Belongings that I wrote up my own list in response. It's at my house, and there are some things that he has that I want back.
Well, the issue is right now there's an order that was signed that allowed him to retrieve these items. Now, all
Right.
of these items, as we sit here today, are items of marital property that aren't to be gotten rid of or gotten sold. Ultimately, the divorce hasn't been finalized. This is a temporary order,
Right.
but there's an order ordering you to allow him to retrieve these items.
Right. The thing of it is, I mean, he texted me as he was the second time he came. He had texted me because I checked my phone after my daughter had come in and told me he was at the house. And it said that he was just letting me know he was pulling into town to get the rest of his stuff. I was at work. I didn't even know.
A boat motor?
And I couldn't very well leave work again. So,
much less multiple?
And he didn't give me enough time. And, I don't have a problem with him coming to get the rest of his stuff. He just needs to let me know in advance to get everything arranged. I don't have a problem with it. And the stuff out in the yard, if he wants his stuff, then he could have shot me a text at any point in time. So I'm going to come pick up the car, or I'm going to come get the stuff out of the yard. There's also a big crate sitting there that's got doors in it from one of the jobs he did. The doors belong to Excel. I don't know what I'm supposed to do with them. They're just sitting in the yard. And he hasn't taken care of any of that either. I can go home and take pictures of all the stuff that's still sitting there. There's still stuff. He's still got stuff in the garage.
Right. Wait, so your home is in Eureka.
Uh-huh.
Do you work in Eureka or do you work out of town?
I don't work in Eureka anymore. I was working at G&W.
Okay. Are you currently working
Yes.
in Eureka or out of town?
No. I'm working at Amazon.
All right, Mr. Paul, I'll give you an opportunity to make a brief response if you have one.
I do, Your Honor. Your Honor, my client has multiple text messages asking to do that. He's been ignored, like I stated previously. And if I need to subpoena the Greenwood County Sheriff's records, they were called out on multiple occasions. Mr. Ashdown actually has one of the incidents on video where he was threatened with arrest by the Greenwood County Sheriff's Office if he stepped foot in the house. There's been multiple times that he has tried to retrieve these items. He's made multiple attempts with the respondent to try to work this out. And he had me file this motion as a last resort, Judge. At the end of the day, he wants his stuff back. We would like to know from the respondent a date and time where he can come out and get his stuff. Thank you.
Well, that's what I was going to suggest, is arranging a time where this can be accomplished. Berger.
All the text messages, I would like to respond to the text messages. All the text messages he sent me about coming and getting his things were long before he filed paperwork. There's been, like I said, he's not made mention of it, not once, and he's only shown up twice since we got it. The first time, the day I got served, and the second time that he showed up.
I get that, and right now, and we'll get into that if we have to. I'm hoping we don't have to.
Uh-huh.
I'd like to resolve this in a manner in which we don't have to come back and do that.
Okay.
But what I'd like to do is establish a date and time where he can come out and retrieve these items.
I don't know. Hang on just a second. You got it? There? next Saturday at, yeah, December 9th. What time? 11 o'clock
I know how much.
next Saturday.
Does that date and time work for your client, Mr. Pa?
Yes, Your Honor. He did state that it may take more than one day to get all of his stuff because, as the respondent had said, there is a whole bunch of stuff out there. So what I would say is if everything is not retrieved, that the parties come to an agreement on a secondary date where he can get the rest of his items.
You want to establish that date now?
Please.
Ms.
And then-
Baumgartner, if the retrieval isn't completed on December the 9th, would December the 10th be an appropriate time to conclude?
Of course
I
not.
have to work on December the 10th, so it would have to be the next Friday or Saturday. I know with his work schedule, or maybe.
Judge, December 16th would work, that next Saturday.
Okay.
And let's just make that at 11 as well.
That's fine.
The
Thank
guy
you.
just wants his stuff. You got no need for his
All right,
stuff.
and I'm hoping this will all be done peacefully without the need to have law enforcement called out. So the easier that you all make this, the better it's going to be for the both of you in the long run.
Mhm.
Now, again, this is all marital property. Items aren't to be sold, thrown away until it's all been sorted out. These are just temporary orders for now. Ultimately, if there's a dispute over property items, we can litigate that if need be. Now, as far as the request to make a finding in contempt, I'm not going to rule on that at this point.
She'll get it in the future.
If there's any issues in these dates and getting the items returned, then that's something the court will reconsider, but I'm going to take it under advisement at this point. If you all have text messages and things like that you want to present, if need be, I would suggest going ahead and having those ready to present. But right now, I'm taking that issue as well as the request for fees under advisement. What I'd like to do, and let me ask this, Mr. Pa, are y'all doing discovery, or where are we at in timeline and setting a final hearing or trial?
Judge, honestly, the respondent's in default, and we were going to file basically just a judgment for default. And but Mr. Ashdown was not going to make that happen until he got his personal items back and saw what was actually there or not. So that's where we're at procedurally.
Okay. Well, why don't we set a status hearing sometime after the 16th, just to see where everybody's at.
That would probably be a great idea, Judge.
Angela, do we have a 30-minute slot sometime after December 16th? It might be difficult to do there leading into Christmas, but I want to go ahead and have something on the calendar.
Judge, I have December 20th at 4 o'clock.
December 20th at 4 o'clock. We can do a status by Zoom. That's a Wednesday.
I have to work that day,
Too bad.
so I'll have to make arrangements to be able to do it at work on my phone.
Okay. Well, that's probably a good time to do it because any of these dates around Christmas and New Year's are tough to fill up. So if you can make that available on your calendar, I'd like to go ahead and utilize December 20th at 4 o'clock.
Okay. I'll see what I can do. And then I will get back to you guys. I will figure out how to get back to you guys and if that won't work. So
Make it work.
all right.
Just email me. I'll email the court. Fair enough?
sure.
Okay.
All right, Mr. Power, are there other matters that need to be addressed today?
Not at this time, Your Honor. Thank you.
All right. And Ms. Bumgarner, anything else?
No, sir.
All right. If there's nothing further, we'll be in recess. Thank you all.
Thank you, Judge.
I did not particularly care for her. I don't know if anyone was able to tell that. She was not my favorite litigant today. Yes, just give the man his crap back. You're talking about how it's nothing but junk and it's so bad that you had to throw so much of it away. Then give it to him. If it's garbage, let him have it. Why do you want to hold it? Oh, golly, that woman just irked me. Yeah. I think what you guys are seeing is when she tells other people to have a good night. When other people are going to bed, that it's her goodbye, and you guys are thinking that it's her goodbying us, when really she's goodbying whoever else is leaving. Yes. Yeah, see? I explained it terribly, but I knew what was going on. Yeah, I am not spicy. That is not me spicy, sweetie. I'm as spicy as a tomato. Oh, there are some things I get fired up about. I don't think you guys will ever see them because I don't think any of you will piss me off that bad. I can't help you on that one. All right, guys. Oh, it is now almost 2 a.m. and I have to drive my daughter to an appointment tomorrow, and I have to volunteer at the concessions tomorrow as well. I have to do that again, but it's okay. It went well the last time. They let me sit and do the cash. Only once did someone have to jump out from the order taking spot and help me with the line from cashing because there were a lot of people. A lot of people. Tomorrow it's supposed to be extra busy because there's a middle school play or musical or something going on at the high school. So there will be lots of parents. There was the last time too. The kids did Finding Nemo. They kept coming to the concession stand and they had, like blue face paint on or they'd have like, streamers coming out their, waistband or something and they'd tell me what animal they were and, coming up. I was a shark in the play. It was adorable. Oh, I loved it. I absolutely loved it. Oh, thank you so much. I keep those buttons well hidden. For crying in the mud, I'm the one that says things like golly. You deserve it, Letha Mays, sweetie. You're doing great, and you're going to grow every day, honey. You just keep it up. Ooh, pasties, yum. The edible kind. I remember being a donkey in Peter Pan. Yeah, thank you. Aww. That's so cute, Seattle John. Aww. Thank you so much, sweetie. I love you to pieces. Much love. You are going senile. Your spelling is proof. And the contextual errors in your messages, yeah, it's proof of it. You keep trying to blame it on the voice to text app. But I know differently. You're getting to be an old man with an old brain. Pretty soon we're going to just call you Joe. That is sweet. That's always a sweet thought. I love interacting with kids. Yes. Yes, Tammy 13. You've gone to bed like 5 times now. When it's 9:30 in the morning there. Yep, and it's 2 a.m. here. Or it can't be 9:30 for you. It's gotta be almost 10. Because the 30 wouldn't make any sense because it's a solid hour here. Now my brain is trying to brain and it's not doing well at it. And you can blow me gummy kisses. They need a dentures emoji. But it would have to be animated because it would the smiley face would just sit there going. See, I was so close. I was gonna say 9, and then I thought, no, it's been longer than that. It's gotta be closer to 10. Oh my gosh. Okay. Oh, you guys, I love you all so much, and you know it. I wouldn't even have a reason to be here if it wasn't for you guys. So thank you. And my replay crew, thank you guys too. I wish you guys could be here, but I understand work and life and kids, and this is really a different hour for somebody doing something like this, you know? So, but I'm happy to take this time slot. This is mine. This is my spot. All right. Be safe, be well, sleep sweet, and thank you for getting me to 1,500 subscribers. Much love, y'all.